Welcome back, dear students. Today we will learn certain fundamental rights of accused persons, including the convicted persons. That is the protection given by our Constitution in respect of conviction for certain offences. Article 20 of our Constitution deals with three such fundamental rights which are given to accused persons, and those rights are to be considered seriously by the courts whenever an accused person is to be convicted. The first and foremost fundamental right of an accused person is that you cannot apply, you cannot increase the penalty for an offense from a back date. That is known as right against ex post facto laws. Suppose today I have committed theft and the penalty provided is 3 years. Tomorrow you are going to change the law and you want to make penalty of theft 4 years instead of 3 years. But the date on which I committed theft, its penalty was 3 years. You cannot increase this penalty retrospectively from a back date. This is known as right against ex post facto laws on criminal side. The first part of Article 20 Clause 1 prohibits the retrospective application of criminal laws if a new offense has been created or penalty of old offense is increased. So such laws which create new offenses or they enhance the penalty of previous offenses, they cannot be applied retrospectively to punish a person for that act which was done in the past. Thus, a criminal law which creates a new offense cannot have a retrospective application from back date, as otherwise it would have been violative of Article 21, my right to life also, my personal liberty also, because you are increasing penalty from a back date, and on the date of offense the penalty was less. And if you are applying such a criminal law retrospectively, it would be against the principle of reasonableness, justice, equity, and good conscience also. And it would be an arbitrary legislation. You have created a new offense. You have enhanced the penalty of an old offense from back date. You cannot do so because it is against the concept of my life and personal liberty. And at the same time, under Article 20 Clause 1 of our Constitution, I have a fundamental right that no criminal legislation enhancing the penalty or creating a new offense can be made applicable from a back date. It has to be prospectively applied. If you are changing the law, then the new law will be applicable from the date of enforcement only and not on the past transactions. I'll mention it here for your benefit. Only prospective application. Such criminal laws can be prospectively applied. You can increase the penalty from today, from a future date, but not from a back date. Okay. So the net idea is that if a criminal legislation increases the punishment for an offense, which was an existing offense, then such criminal law also cannot be applied retrospectively. As such, retrospective application would be unreasonable, arbitrary, unjust, and unconscionable. Now take the reverse of it. What will happen if the law reduces the punishment? Truly speaking, the reduction in punishment is also to be applied prospectively, because there is no such prohibition under Article 20, and it is allowed. If the law is reducing the penalty, can this reduced penalty be applicable to all those offenses which were committed in the past before application of new law reducing the penalty? See, it can be applied retrospectively if legislature allows so. If legislature does not allow, court may give him minimum punishment at its discretion. As a lawyer, you can argue before the courts that, see, sir, the penalty for theft has already been reduced by the legislature from 3 to 1 year. Although when I committed offense, the penalty for theft was 3 years. But since the parliament is kind enough to reduce the penalty, so please give me minimum punishment. That you can plead. But not as a right, you cannot say that since the parliament has reduced the penalty of theft from 3 years to 1 year, now as a right, I should not be given punishment beyond 1 year. You cannot say so. It depends on the language which the legislature is using while reducing the penalty. Dear students, at this juncture, when the penalty is reduced, we have a doctrine of beneficial construction also. If the offense is abolished by a new subsequent law, suppose sedition, 124 capital A IPC, there is demand in the public and in the newspapers also, right or wrong, that sedition offense should be abolished. So if the offense is abolished by a subsequent law, what will happen to the previous cases which are pending under section 124 capital A of IPC, even if sedition is abolished in future? Or if its punishment is reduced. So if the offense is abolished by a subsequent law or punishment is reduced and the said subsequent law is applied retrospectively, legislature says that this reduction in penalty has to be applied retrospectively, then accused who had committed the offense earlier will get the benefit of that law, because the new law says that penalty is reduced or offense is abolished. Sedition is no more an offense if parliament says so. Then if the law is applied retrospectively, then accused will get benefit of that law. This is doctrine of beneficial construction. However, if such beneficial legislation was not applied retrospectively, if the new law is prospectively applied, then accused can certainly plead the benefit of new legislation, and court, after convicting him, can reduce or minimize his sentence. You can plead before the court that, sir, see, the parliament has reduced the penalty of theft from 3 years to 1 year. Now your lordship is requested to give him minimum punishment. So you can plead that. You will have a good point for your client when you say that parliament has already reduced the penalty. So please give me minimum punishment. This is the doctrine of beneficial construction of a legislation. Then second fundamental right of the accused under Indian Constitution is Article 20 Clause 2, that is double jeopardy. Literal meaning of jeopardy is peril or trouble, but in criminal law, jeopardy means punishment. You cannot punish me twice for the same offense. Suppose I committed a theft on 1st January 2010, and after the trial I was punished, say in 2017. 3 years imprisonment was awarded to me. I was sent to jail. I served out 3 years imprisonment in jail. And when I came out of the jail, on the gate of the jail itself, police again arrested me. पुलिस ने बोला कि अरे बहल साहब आपने 1st January 2010 को theft किया था, you are being arrested again. I said, how come? I have already served out my sentence in jail for 3 years. You cannot punish me twice for the same theft. एक बार आपने ट्रायल किया मेरा, मुझे सजा की, मैंने सजा काट ली, अब आप क्या बच्चे की जान लोगे? No, you cannot punish me twice for the same offense. This is a fundamental right given to me under Article 20 Clause 2. And it will be an unnecessary excessive restraint upon the life and personal liberty of the accused, and also it will be unreasonable, unjust, arbitrary and against good conscience. You are putting me into peril once again. This affects my right to life and liberty also, and it violates my fundamental right of double jeopardy given to me under Article 20 Clause 2. But accused has to prove that he has been prosecuted and punished earlier for the same offense in a judicial or quasi-judicial proceedings. If the accused was prosecuted and acquitted earlier, then prohibition of Article 20 Clause 2 will not apply. If I was acquitted because of lack of evidence in theft, which I committed on 1st January 2010, and later on police collects some evidence and files me a supplementary charge sheet against me again, then probably Article 20 Clause 2 will not protect me because earlier I was acquitted. Although Section 300 CRPC will come to my rescue, that a person once convicted or acquitted cannot be retried again. Principle of auriferis acquit and auriferis convict will apply, and probably I shall not be prosecuted again. But so far as fundamental right under Article 20 Clause 2 is concerned, this fundamental right is available when earlier I was convicted. If on earlier occasion I was acquitted, then this fundamental right will not help me. Then I will have to go and see the language of Section 300 CRPC. And it is also essential, dear students, that earlier accused was prosecuted and punished in some judicial or quasi-judicial proceedings. If earlier proceedings were not judicial or quasi-judicial, rather it was only a departmental proceeding, then Article 20 will not apply. Article 20 Clause 2 will not apply if I was punished earlier in departmental proceedings. Suppose a police constable committed theft in Malkhana. He had stolen some case property which was kept in Malkhana. Now he will be prosecuted for theft under Section 379 IPC, and he will be hauled up for departmental proceedings. Suppose in departmental proceedings he is convicted and he is removed from his services. Later on, he is put on the trial for the theft. Now he is punished by judicial magistrate also. 7-year imprisonment is awarded to him for theft. Police constable cannot say that earlier I had already been convicted in my departmental proceedings, so double jeopardy will apply. Double jeopardy will only apply when earlier a person was convicted in a quasi-judicial or judicial proceeding. Departmental inquiry is not a judicial or quasi-judicial proceeding. So if a person was convicted in his departmental proceedings, that conviction will not help him under Article 20 Clause 2 because that conviction is not a conviction by a judicial or quasi-judicial authority. Third fundamental right, my dear students, available to an accused is Article 20 Clause 3, right against self-incrimination. I'll correct it here. It is right against self-incrimination. This means that you cannot compel me to give evidence against myself. Self-incrimination means a piece of evidence which is going to be used against me and I'll be convicted on account of that piece of evidence. So I cannot be compelled to give evidence against myself. Suppose police starts interrogation and I have apprehension that if I will give answer to a particular question which amounts to my confession and I am likely to be convicted. So I'm not bound to answer that question because it is my fundamental right against self-incrimination. If I have committed an offense, the burden of proof is on the prosecution to prove that I have committed such and such offense. I cannot be compelled to give evidence against myself. Dear students, you must have seen in a few Hindi movies when the sitting judge in the courtroom asks few questions to the accused person, he becomes deaf and dumb. as if he is not hearing anything. जज साहब ने पूछा क्या आपने मर्डर किया? He says, आपने गोली चलाई थी? He doesn't give the answer because he has a fundamental right against self-incrimination. Why he should answer that मैंने गोली चलाई थी या नहीं? Why should I say yes that I committed murder? Burden is upon the prosecution to prove, and I have a fundamental right not to give evidence against myself. So, dear students, according to Article 20, Clause 3, the accused cannot be compelled to give evidence against himself. The protection is from mental as well as physical compulsion and is available at all the stages, including the trial stage. This fundamental right and protection is available at all the three stages of criminal proceedings, that is investigation, inquiry and trial. But there is a big rider on this fundamental right. It must be noted that protection is with reference to personal knowledge. If something is in my personal knowledge, because I committed murder, I committed rape, it is in my personal knowledge, so I am not bound to answer. But things which are not in my personal knowledge, suppose police says that you will have to give your thumb impression so that we may compare it with the original document for finding out the forgery. So that giving thumb impression is not in my personal knowledge. I will have to give my thumb impression. Or police says give your hair sample, because where the rape was committed, few hairs were found on the bed, so that police may compare that your hairs had fallen on the bed at the time of rape. So giving hair sample is not in my personal knowledge. Or police says give your blood sample so that DNA test may be done to find out the paternity of the child. So all these things, giving thumb impression of the accused, taking hair sample of the accused, taking blood sample, taking DNA profile, accused is bound to give. The protection is available only for those things which are in the personal knowledge of the accused person. We have a leading case, MP Sharma versus Satish Chandra, decided by the Supreme Court, that this fundamental right of self-incrimination is available even to a suspected person. Suppose I am not named in FIR. Police is coming to my residence daily for investigation, although I am not yet named in the FIR. I am a suspected person. Still, this fundamental right is available to me. Because if today I am suspected, after my statement, after my confession, police is going to arrest me and send me to jail. So it was held in this case, it is not necessary that the concerned person was an accused at the time when he was compelled. Rather, maybe at that time he was only a suspect. And as I told you, later on, he may be made an accused. So even in such cases, suspected accused person is also entitled to get the benefit of this protection. Sometimes a person lodges the FIR as complainant, and later on he is arrested as an accused. Initially, a person is complainant. He turns out to be accused after 2 days. So this protection of right against self-incrimination is available to suspected accused also. And dear students, this protection is against a compulsion to give evidence, against his own self, and therefore, if the accused voluntarily gives the information to the police, then Article 20, Clause 3 will not apply, because nobody is compelling me. Voluntarily, I am going to the police station and telling to SHO that yes, sir, I have committed the murder. I'm sorry, I have committed murder. Nobody has compelled me. So if there is no compulsion, the question of application of Article 20, Clause 3 does not arise. And dear students, this protection is only with respect to the statements which can be used as evidence against the accused. Witnesses do not get this protection under Article 20, Clause 3, because this protection, this fundamental right, is available to the accused person only. Witnesses may seek protection under Section 132 of Indian Evidence Act, but not under Article 20, Clause 3. You see, this protection is not available to witnesses when Mrs. Indira Gandhi appeared before Shah Commission. Shah Commission was conducting inquiry. She appeared before Shah Commission as a witness. She claimed that I will not answer few questions because of Article 20 Clause 3. She was not entitled to protection under Article 20 Clause 3 because she was not an accused. She was a witness. We have another leading case, State of Bombay versus Kathi Kalu Agar, which says that if some facts are visible and manifest clear, then protection of Article 20 Clause 3 will not apply. Suppose police has already collected sufficient evidence against me, and I have also answered that question. So if things are visible and manifest, then even if I say that I do not answer, I will not answer, it makes no difference. But Supreme Court says that protection of Article 20 Clause 3 will not apply if certain facts are visible and manifest. And this protection applies only with respect to the facts or information based upon the personal knowledge of the accused. It is in my personal knowledge where I have thrown the dead body. I will not answer. I will not. Even if police is asking me कि आपने dead body को कहाँ छुपाया है, I will keep mum because it is in my personal knowledge where I have kept the dead body. किस नदी में मैंने dead body को फेंका है, I know it. It is in my personal knowledge. I am an accused. I have a fundamental right. I will not answer where the dead body is kept. And this protection is not only with respect to compulsion, but also with respect to any kind of mental compulsion also. Neither physical compulsion nor mental compulsion can be put on me for answering certain questions which I think will go against me. Then, dear students, we have another leading case, Nandini Sadpathi versus PL Nani. In this case also, it was held by the Supreme Court that prohibitive scope of Article 20 Clause 3 arises at the very stage of investigation, and the protection is available at all the three stages: IIT, investigation, inquiry, and trial. This protection is available at all the three stages of the criminal proceedings, that is IIT, I for investigation, second I for inquiry, and third T for trial. Thus, this protection of Article 20 Clause 3 is available at the stage of Section 161 CRPC also, when the police records the statement of accused person. And it is available at the stage of Section 313 CRPC, when the magistrate or the session judge records the statement of the accused person under Section 313 at the close of the evidence of the prosecution. And this protection is extendable and available at the stage of Section 315 CRPC, when accused is produced as a defense evidence, as a defense witness also, because he is an accused as well as a witness. So as accused, he is entitled to that protection while standing in the witness box, giving his evidence before the court. So dear students, this Article 20 Clause 3 gives the protection only to the accused persons and not to the witnesses. In this case, it was held that Section 161 Clause 2 of CRPC is in consonance with Article 20 Clause 3, which gives me a fundamental right not to disclose the evidence which is in my personal knowledge to the authorities. So in nutshell, dear students, we have three fundamental rights for the accused persons in Article 20. Article 20 Clause 1 says no retrospective application of criminal legislation, especially where the penalty is enhanced or the offense is abolished. Second is double jeopardy, and third is right against self-incrimination. So dear students, thank you very much. God bless you.